I declare the motion passed. Motions under Article 73, Bracket 5 and Bracket 10 of the Basic Law. First motion. Motion to be moved by the Hon.CHU Hoi-dick to summon the Secretary for Justice to attend before the Council on the 21st of March 2018 to testify and produce documents. Members who wish to speak on the motion will please press the Request to Speak button. I call upon the Honorable Eddie Chu to speak and move the motion. Thank you, President. My motion seeks to summons the Secretary for Justice to attend before the Council on the 21st of March 2018 to testify or give evidence and to produce all relevant papers, books, records, or documents in relation to whether a law will be enacted as soon as possible on freedom of information protected by the Hong Kong Bill of Rights Ordinance, when such a law is to be enacted, and matters related to the persistent withholding of public information by government departments at present. President, members. This is a motion moved pursuant to Article 73 of the Basic Law. It is to summons officials. It can very well summarize the other summons motions that were moved in the past few weeks. Every such motion represents a hanging issue. We have these issues because the administration is unwilling to provide necessary or crucial information, and that is why the issues are unresolved, or in fact they deteriorate. President, allow me to say again that starting with the purchase of water cannon vehicles by the police, the information about that has been withheld by the administration. And then the Palace Museum at the West Kowloon Cultural District, Ms. Tanya Chan requested the administration to provide information. Say, for example, the consultants' comments on using WKCD and the feasibility study of using WKCD as exhibition, performance, and catering venues. Mr. Chu, these have been debated. Please come back to the motion under debate today. Yes, I am speaking on the motion. I am saying that the government departments have been withholding public information persistently. And I am saying that starting with the first motion moved under Article 73 of the Basic Law to summons officials and also to ask the administration to provide information, we actually are already debating on this very motion. From water cannon vehicles to the Palace Museum to Wangzhou to the Hong Kong-Zhuhai-Macau Bridge, all these issues are of concern to the public. However, the administration makes use of specious arguments to refuse to disclose information so that the council and the public are kept in the dark. They have no way to monitor the administration, and there is no way the public can come to a reasonable judgment. The administration refuses to give information, Madam Deputy. Sometimes they do give you the information, but they give you the information with a lot of the details redacted. The latest example is that when the Finance Committee discussed the Capital Works block vote or block grant, there was the proposal to have an agricultural park at Kutong. A few members asked the Food and Health Bureau and the AFCD to get study papers on the agri-park. And then what they got was something like this that I'm holding in my hand. This paper has a lot of its contents redacted. And Undersecretary, I can let you see this paper in a moment. With all the information deleted, well, we don't understand why the information has to be redacted. Say, on this page that I'm looking at, it has redacted the information on irrigation water for Agri Park in Kutong. Now, how much water there is that can be used for irrigation? Why is that information to be covered? Certainly, it affects our discussion of the matter. But who would be harmed if the information is disclosed? I fail to understand, because the administration has not explained themselves. When the AFCD and the FH Bureau cover up the irrigation information, they have not given any explanation. Madam Deputy, this is the latest example, but there are many other subjects which the public have criticized for a long time. And there is a blockade of discussion because of the lack of information. There are two major examples. One, the Disney theme park. The development and operation agreements that were entered into with the administration. It is like a straitjacket controlling the behavior of the administration with regard to the future development of the Disney theme park. It is like a transparent straitjacket. It is an invisible straitjacket. Every time at meetings, we demand information from the Secretary for Economic Development. And then every time he would say, sorry, we signed the agreement and we could not do A, B, C, D, E. And then we said, we should like to see the agreement. And then he would say, sorry, we can't let you see it. And the second major example is, well, this is even more irritating, and that is the divestment of public housing resources to Link. And I'm talking about that divestment agreement. Undersecretary, before I spoke, I took a look at the Code on Access to Information. If I could refer to 2.9a and 2.14a, 2.9a, it says if the information is disclosed and the department's negotiation or commercial discussions would be harmed, then it does not need to be disclosed. And then 2.14a, if the information is disclosed but it's beneficial to the public, then even if the third party does not agree, you can still disclose the information, and the third party may be the link. We have been asking for such information for so long, but all these years the administration has refused to produce the divestment agreement. Madam Deputy, there are two parts to my motion. First, I am asking the Secretary for Justice to explain to us why departments can persistently withhold public information when this is perfectly permitted by the Code on Access to Information. Why can they persistently withhold that kind of public information? Secondly, the other main point in this motion is that when the SARG will discharge its responsibility to legislate on freedom of information, to constrain itself, and also to return this right to the public. Here, I'd like to refer to the Hong Kong Bill of Rights together with members, and I'm talking about Section 16, which states, Section 16, bracket 2, everyone has the right to freedom of expression. This includes doing so through language, publications, art, or any other form chosen by the individual. This is not bound by national boundaries, and to also express their thoughts, and also to seek and express, and also to obtain any kind of thoughts. Actually, Madam Deputy, this echoes the ICCPR Article 19.2, that everyone has the freedom of expression. This right shall include freedom to seek, receive, and impart information and ideas of all kinds. Now, members may say that this is about freedom of expression. But this discussion should focus on asking the administration to provide information to the Council and the public. And you may ask whether this is related. Of course, they are related. They are directly related. Because if we take a look at what happened in July 2011, the United Nations Committee on Human Rights, in its general comments, number 34, paragraph 18, commented on Article 19, bracket 2 of the ICCPR. It actually explained that article. It said,
Paragraph 2 of the International Covenant on Civil and Political Rights embraces a right of access to information held by public bodies. Such information includes records held by a public body, regardless of the form in which the information is stored, its source, and the date of production. 即係話
In other words, the Hong Kong Bill of Rights, Section 16, according to the UN Human Rights Committee's explanation and their understanding, it actually empowers the public to obtain information that has to be supplied by the administration. I believe there is urgency for us to entrench this in legislation. Madam Deputy, I remember there was a chance at the AJLS panel when I had a dialogue with the Director of Administration, and we were talking about the archive law.
The Director of Administration said that for the archive law and the Code of Access to Information in Hong Kong, we have all the legal provisions there, and what we are lacking is just the issue on criminal liability. In other words, when you break or breach those legal provisions, what criminal liability are you subject to? Well, that, of course, means the liability of civil servants. So I can't accept the fact that starting from 2013, the government has been shifting the responsibility to the Law Reform Commission. And this year, the Law RLC is coming back, but then still they are dragging their feet. If the Director of Administration speaks the truth, then we are all actually fully equipped with the necessary legal provisions. There is everything that is needed in the Code of Access to Information. The question is whether the government is willing to legally bind civil servants' behavior with some kind of law. So, Madam Deputy, why are we so concerned about this? The Undersecretary, of course, will mention that last November he answered an oral question of Mr. Charles Mok. He will be saying the same thing again. He will be saying that the Code of Access to Information, there are several thousand applications each year, and some 90% there will be the requests will be fulfilled, and we have the Law Reform Commission working on it, so there shouldn't be any problem. And what I said shows that there is indeed a serious problem now. Well, don't tell us that 90% of the requests have been entertained. The remaining percentage of requests not entertained is the crust of the issue. What are the subjects they are on, and the impact on the public is really the crux of the matter. So please don't repeat your answer to the oral question earlier. Now, under Acting Secretary, I hope that the Secretary for Justice can come to us and explain to us what has not been done, explain clearly when legislation will be enacted and why the legislation is not enacted. And I propose that the question to you that the motion moved by Hon.CHU Hoi-dick be passed. Under Secretary for Constitutional and Mainland Affairs. Madam Deputy, Mr. Eddie Ju raised this motion. Is related to Code of Access to Information and Freedom of Information. The government has attached importance to publicizing, making available information. We would like to implement Code of Access to Information. And the code shows the government's open policy, and the overriding principle is that unless there are good reasons for not disclosing information otherwise, the government will be providing information to those who request information. In the Part 2 of Code of Access Information, there is reason why the government can refuse to give information. Apart from those circumstances, the government should be disclosing information to requested by members of the public. Part 2 includes provisions relating to information related to security, law enforcement, and litigation. These are all very good reasons for rejection of the request. And the code also specifies the procedures and the time limit for entertaining requests for information. Regarding enacting Freedom of Information Act, the Law Reform Commission has established a working group on freedom of information, which is studying this subject, including the proposal to enact freedom of information law. So they are working on it. And the working group is now looking into the situation of Hong Kong in relation to making available information. And they are also looking at the laws in overseas jurisdictions, and they are conducting a detailed review. And they will not be just looking at a few examples. They will be able to then make appropriate proposals for reforming the freedom of information regime in Hong Kong. I will be listening to members carefully, and then I will respond. Ms. Claudia Mo. Hong Kong will soon become a city without a memory. Of course, we don't have an archive law. But what about Freedom of Information Act? That ordinance that will be very far off. You have newly joined the government. I believe that you have read through past documents. In 2012, C.Y. Leung was standing for election as the chief executive. He told the Hong Kong Journalists Association when he met them, there were cameras all around him, there were TV and radio stations, journalists and newspaper journalists. He promised that there would be a Freedom of Information Act. It's easier said than done. Well, you would never deliver your promise. So in May 2013, the C.Y. Leung's government announced that the Law Reform Commission, the LRC will proactively look into drafting a piece of Freedom of Information Act. That was in May 2013. Now it's been 5 years on. And whenever we ask you, then you will be giving the same answer all the time. This is a most irresponsible government. Over 100 countries around the world have already enacted Freedom of Information Act. What do we mean by that? That there is this legal requirements and also penalties in relation to provision of information, and it's legally binding. Well, what is the significance of that? It's about people's right to know, and that is so very important. Or else the government will have all the say. Whenever you ask them for information, they say it's a confidential information. Well, they will say it's politically, commercially sensitive information. The code of access to information is just a code. It is not legally binding. Last time I asked Mr. Chan, well, if you can't do it now, maybe you can add in some penalties to the code. I know that it would be difficult for you to give an answer. You are not from the DOJ, so you didn't give me a reply. So we've been stuck in the past 5 years. Do you know that Freedom of Information Act, in the U.S., it is called Sunshine Law, and that is to say, government is duty-bound to do it. It has its duty to do it.
To publish and promote openness. 係咩都要開放嘅，一個政府。
Well, the government should act in an open manner, and you must discharge your responsibility. You would proactively make public information without people requesting for it, even though such information is something that you would not like to disclose. Especially, you should entertain journalists' requests. There are so many online journalists today. Everyone is a journalist in some sense. So when they come to you to get information, you have the duty to provide the information. This is a constitutional protection for people. Let me quote again. Constitutionally, this is to protect or uphold the right of the citizens of the country to obtain the relevant information. This kind of concept is very important.
Right of access to information. 咁你話呢啲即係比較新潮嘅嘢啦，現代嘢係嘛？係網上。
You may say that this is a modern approach to things. No, that's not true. Don't you know that which is the first country to enact the Freedom of Information Law? It is Sweden. You said that well, Sweden is a very open country, so that we can guess it. But it would never imagine when it enacted the Freedom of Information Act. It was enshrined in the Constitution to safeguard people's right to get information. You can imagine it. Maybe you will say it's, say, 2 centuries ago or even longer. It's 1766. 1766. Sweden was the first country to enact the Freedom of Information Act. Now it's 2018. Hong Kong is people are still begging you to enact it. Please do it as soon as possible. 5 years ago, I was on the same seat, and I was talking, say, to the same bureau. Of course, you were not there then, and you were you would try to muddle through the issue. You can't drag your feet like that. And this is something between the relationship between the government and people to the Chinese people is a relatively brand new idea. Now, well, you can say IT, news, concepts, newspaper concept were actually came from the Western world, and in the China, we're agricultural society basically. So I know that we can't achieve everything at one stroke. I'm not just talking about 5 years. The Hong Kong Journalists Association was starting from the colonial days. Have been urging for this for some 20 years. You've been stalling the matter all the time. The British colonial government didn't do it. Why? They were so busy. Well, especially towards the latter part of their era, Chris Patten was debating, arguing with Beijing every day, and they couldn't do it. And now from 1997 up to now, you're dragging your feet. I was witnessing all these, and I was actively involved in the matter for at least 5 years. Some over 100 jurisdictions have a Freedom of Information Act from A to Z. From A1, Azerbaijan has this. And you said that maybe they are not very free and open societies, so they're just, having this kind of law as a symbol, and I've not studied in depth into their law, but I know that I read something about their doing it 2005. 13 years ago, they already had this access to information law. This is a law, so it's legally binding. It's not a code. And 2005 is quite late. It's just 10 years ago. They are just moving ahead a bit earlier. And before that, they were a closed society. Actually, before that, they had another piece of legislation, law on freedom of information. And they thought that the earlier law was not powerful or strong enough. So in 2005, the Azerbaijan government decided to put in place an even stronger piece of legislation to allow people to get information from the government. And why do you have to know so much, you may ask? Policy formulation of the government. Well, how is the process like? How come that Hong Kong people don't have the right to know about it? Well, starting from, say, the XRL in the past 10 years, how was the discussion like? Shouldn't you have a complete set of information for us, how the discussions went and how was the negotiation like? They were recalcitrant not to provide it. And also for the Hong Kong Palace Museum. And Mrs. Carrie Lam was smug and complacent, and she said that it's right that you don't know about it. You just don't have the right to know. We are very tight-proof in terms of keeping the information to ourselves.
This is not what should happen to a modern society. For the Wang Chau incident, you might remember that housing department staff had a chat and they soft lobbied the rural powers, but there were no records for their meeting. So who could tell whether there weren't any records? You said there were no records at all, which was hard to believe. For the most crucial meeting, you said there were no records. For the Avenue of Stars in 2016, the LCSD went to a developer, and at that time they said it was out of public interest, and they came up with an improvement plan for the Avenue of Stars, and they only approached a single developer. And Sino Group and Jerry Group filed judicial reviews against the government, so or against the LCSD. So what sort of decision did the LCSD make? The LCSD talked about public-private collaboration, and New World was the private party. So why did they identify New World? So Sino Group and Jerry Properties asked why they weren't approached, because they were also interested. So the plans went up in smoke because it was just not sensible. For the Code of Access to Information, I wanted to see the contract signed by the LCSD, and they rejected my request because they said the document was confidential and it would not be disclosed. So that was really ridiculous. I'm not trying to see an agreement between private parties. The Avenue of Stars belongs to Hong Kong people. It is a public facility, but they refused to offer the information. I went to the office of the Ombudsman, and the Ombudsman went back and forth with them requesting the information, and 2 years later, I remember that in around September that year, the contract was given, but a lot of information was masked out of commercial confidentiality. It was a matter of great public interest. It was a private agreement, in a way, between a government department and a private company, and other developers also complained, but eventually Sino and Gary Properties withdrew their JR applications. For the Code on Access to Information, Carrie Lam promised last year that they will do something. So again, it was another of the casual promises, but nothing was mentioned in her policy address. In terms of the punishments, you either insert some penalties in the Code on Access, but otherwise department heads will not offer the information. You cited legal, commercial, and political sensitivities, so the information would not be disclosed. But in 2016 to 17, the Office of the Ombudsman received the most number of complaints. And journalists and politicians asked for information from the government based on the Code on Access, but they were refused. So 85 complaints were made to the Ombudsman. In today's world, everyone can see what is happening. The government is trying to promote innovation and technology while they conceal everything. They prefer to operate in the dark rather than under the sun. Mr. Charles Mok, I support the motion moved by Mr. Eddie Chu pursuant to Article 73 of the Basic Law to summon the Secretary for Justice to attend before the Council to whether a law will be enacted as soon as possible on freedom of information protected by the Hong Kong Bills of Rights Ordinance and matters relating to the persistent withholding of public information by government departments. Ms. Eddie Chu and many members would support dealing with the issue via the Basic Law for two reasons. First, as the two earlier members have said, Hong Kong faces a lot of governance issues and members cannot achieve what they want to do. and information is withheld from the public or even from members. So this is the root of a lot of governance issues in Hong Kong. And number two, we have no other option. The government has been procrastinating for decades. In terms of the legislative timetable, we are dealing with two pieces of laws, including the Archives Law and the Freedom of Information Act. The Archives Law mandates government officials to maintain and disclose public files of significance, and the Freedom of Information Act would maintain the public's right to know, and both ensure that the public can receive open and transparent information. The Mrs. Carrie Lam signed a Freedom of Information Act with the Hong Kong Journalists Association, promising to realize freedom of information, and C.Y. Leung also signed the same pact. But we hope that Mrs. Carrie Lam would fulfill her promise. Yesterday, when the Chief Executive addressed the report of the Office of the Ombudsman, he mentioned legislative issues for the Freedom of Information Act and the Archives Law, but the progress is rather slow. And right to know is confirmed by the UN ICCPR, and UNESCO also established an International Freedom of Information Day, and they hope to foster public right to know and their awareness of government information. And all around the world, in more than 90 countries and areas, this has become a basic right protected by their constitutions. Right now, over 100 countries and areas have established a Freedom of Information Act to mandate how their government would respond to public information requests. In more than 90 countries, the relevant acts have been written in their constitutions. So it shows that there is a wide consensus on legislation for freedom of information, and this is what the government has told us. However, the matter has stalled at the Law Reform Commission, and because of the doubts over the details of the penalties, the work has stalled. And as of now, we only have the Code of Access to Information, which was published in 1995 but have no legal effects. So with more and more data requests from journalists, academics, members of the public, and legislative councillors, we often face lengthy delays, and the information eventually supplied would be less than what is expected. So we feel that the government must make such information open so that the public can monitor the government, and so that they can see whether the government has committed anything illegal. So that's why we must summon government officials via Basic Law Article 73. The government said they have been doing a good job in maintaining archives, but with a lack of legislation, it's hard to monitor the government's work. When the ALC studies the Freedom of Information Act and Archives Law, there were no sign of their discussions. And recently, for the first time, the government said the report by the ALC will be completed by 2018. Earlier, they said the report will be available by the end of last year, so again, the date has been delayed. future consultations should focus on the manner of legislation rather than whether to legislate. I hope the government will stop procrastinating. Since 1995, the government has been dragging on this issue, and in 2013, the government set up a committee on archives law and freedom of information law. I do not want to criticize the LRC's efficiency, but the government should really be conducting preparation work as soon as possible. All around the world, there are acts to protect the access to information, so the Hong Kong government should not procrastinate. We need to know the internal decision-making of the government. That's why we are invoking BL-73. In the past, there were complaints that when handling data requests, the government refused without offering reasonable grounds, and the ombudsman made constant investigations, but they failed to trigger an improvement with the government. The ombudsman have said that the data request system is problematic, and Professor Fu from Hon.CHU inspected numerous government records, and he found that the number of data requests have gone up in recent years. And last year there was 5,200, and it was up 260 compared with a year ago. And according to the Office of the Ombudsman, and in 45% of the data requests there were deficiencies. The government's internal improvement measures were not effective, and that legislation is essential. We all know about the Code on Access to Information, and we know that government officials could resort to all kinds of excuses if they decide to refuse the request. Recently, the government responded to questions on legislation on an archives law, and papers were submitted. The two LRC committees met for nearly 30 times in total, but yet reports are not available. If they encounter certain difficulties and if the public can help, why don't they commence the work sooner? Journalists were refused information by the government, including poisonous milk powder, the report on Heng-Tek School, the number of repeated votes in the 2016 electoral election, and complaints were lodged to the ombudsman, and if they were lucky, they could salvage something. My office repeatedly requests information by the government, but we were rejected for the dishonest use of computers. We wanted to seek more information on prosecutions, etc., and the government said they did not keep such records, and at the end they said the entire computer systems would have to be reworked, so it was certainly unreasonable.
In fact, there were not too many such cases, but then they said they had to revamp the entire computer system before they could give the information. And then the ICSO, when we scrutinized it last time, we said we would really like to know in what circumstances, whether with a warrant or without a warrant, the ISPs would be asked to give information. And the Security Bureau and the police say they did not keep the information. It's impossible. We are just talking about maybe less than 1,000 such cases every year. What is most outrageous, President, is that at the Bills Committee before the summer recess, we said, okay, you did not keep the records, but starting from July, and from July to October, you should then keep the figures. And then coming back in October, they still said they did not do it. It was a matter of their unwillingness to do it. This shows the attitude of the officials towards making public information. President, the second CE signed the charters, but he did not deliver. And we lag behind places in the mainland. We hope this CE will not do the same. In the past year, 3 members, Ms. Tanya Chan, Ms. Dennis Kwok, and myself, together with people in the legal sector, wrote a private member's bill on the archive law. This is being dealt with by the DOJ. Progress is satisfactory. And now, together with other people in the legal sector, we are drafting the Freedom of Information law so that there will not be any more excuse for the administration to drag its feet. I know it's very difficult for a private member's bill to be moved here and be passed, but we have to show the administration that it is possible to write a law. Don't pretend that it is so difficult. Well, treat it as some trigger for thoughts, and don't tell us it's so difficult, because we are doing it. In recent years, the administration says they would like to make public big data. And actually, there are 3 steps. 1, you need an archive law. 2, you have to have the Freedom of Information law. And number 3, the technical side, computer formatting, etc. You are starting with computer formatting. In fact, you are not willing to disclose the information. The administration is saying the CE also supports opening up data. But without archive law, without Freedom of Information law, you are making life difficult for the OGCIO and the IT personnel in the department. They cannot open up any data that the government doesn't want to open up. President, we make use of Article 73, so the S4J and even the CS4A and the CE will not be able to hide behind the LRC and make use of procedures like consultation so they can further drag their feet. Hong Kong cannot wait. We must make the administration admit and handle this issue. President, the Freedom of Information law should include how the public should have the right to seek information from the administration, and also the obligation of the departments to provide the information, and that in principle all the files and data should be made open unless they are exempted. Therefore, we have been delaying for decades, but this is an important piece of legislation. Examples are telling us that the administration doesn't keep records, and it is also very problematic in opening up data. Very often you are criticized for possibly destroying large volumes of files. So there is no choice. We need to resort to Article 73 in order to seek information about how the administration has been handling information. We want to cooperate with the administration so we can have a good archive law, a good freedom of expression law, and also a good scope for opening up data. I support the motion to summons the Secretary for Justice to produce records. Mr. Kenneth Leung. President, I speak in support of the motion. Under Article 73.5 and Article 73.10 of the Basic Law, to summons the Secretary for Justice to attend before the Council to produce evidence and also to give evidence. This motion is about a law on freedom of information. President, allow me to make a macro observation on opening up government data. What is this all about? Just now, Mr. Chow Smok said a lot about the background to the archive law and how it relates to a law on freedom of information, and also how this relates to the opening up of data. President, if you have been paying attention, on Wednesday, that is yesterday, the EIU of The Economist again published the democracy index of many places in the world. The index is the result of a lot of integrated investigation. Amongst 165 countries or cities or places, Hong Kong ranks the 71st. Now, how is this categorized? It says it is a flawed democracy. Actually, if we look at how they give the ranking, there are 5 categories that are given marks. Well, 10 is the highest mark, and the 5 categories are: 1, the election procedure and its scope, and 2, government operation, 3, political participation, 4, political culture, 5, civic rights. If we have an archive law or freedom of information law, it will just do us good in the international community's eyes, at least under function of government and even political participation. We will get better marks, because an important principle is for a government to open up data so the public know what the administration is doing, and the administration will then be accountable to the public. Certainly, the administration, of course, has a lot of considerations towards an archive law and freedom of information law. I think I have gone through those considerations as well. I believe Mr. Charles Mok and other people who are interested have gone through those considerations. Why don't I now go into these considerations and whether they are real worries and how we can deal with them. Now, of course, the administration is not willing to disclose any kind of information. They would regard some as confidential. But if you look at the U.S., in July 1967, it endorsed the Freedom of Information Act. As Mr. Charles Mok said, in many countries and places there are similar laws. In the U.S., the basic principle of the Freedom of Information Act is to allow the public to gain access to government records, including meeting minutes and other kinds of information, without much restriction. Of course, in that act, there are 9 categories of information that cannot be disclosed. If you are thinking of preparing an SAR version of Freedom of Information law, you can also think about what categories of information that cannot be disclosed. Sometimes you may need to wait 10 years, 20 years, or even 30 years after something has happened before the information is disclosed. You can do that. And on the other hand, the administration may say, if we have such a Freedom of Information law, well, you have so much money and you do not need to spend a lot of money on disclosing information. If you say some people would be so pathetic and they just seek information in order to disturb you, then you can ask anybody who seeks information to give his real name. We have the code on access to information, but the code aside, if we have a law to state clearly that government departments can disclose what kind of information in what circumstance, then that would make everything clear. You can also state what information will be exempted. That doesn't need to be disclosed. But of course, the public should be able to appeal against the so-called exempted information, and there should be a tribunal to hear cases about exempted information to decide whether they should really be exempted. If you have a comprehensive archive law, a comprehensive freedom of information law, your records and documents will not be in a shambles. President, for so many times I asked the question at the PAC whether there are minutes for interdepartmental meetings, and then a civil servant or a PS would say, we talked about this, but there are no meeting minutes. Now that is unbelievable. Interdepartmental meetings held within the government are not minuted. I remember Mr. Lau Kong-wah, SHA, he was responding to questions on regulating charities and how he followed up the LRC's recommendation on regulating charities. He said there was no record, and then the WSD also said there was no record about meetings held about lead-contaminated water. Well, they may be passing the buck. And is it true that they are not aware that they should write minutes when they hold meetings? And if they know that the minutes will eventually have to be disclosed, then, well, you can, of course, categorize the information which, say, can be disclosed after 10 years or 30 years. You can do that. If we can have the archive law and the freedom of information law, then your files would be well kept. It would be systematically and categorically kept, and civil servants and principal officials, if you want to seek information, it would be very efficient. This is only going to do good to the operation and openness and transparency of the administration. I can't see why you want to drag your feet for decades with regard to the enactment of an archive law and a law on freedom of information. I hope the administration can give this very good consideration when you say you have a new mindset towards governance. I support the motion.
Dr. Junius Ho. President, I, in principle, support enhancing transparency of all matters within the society. The government must keep good records, and that would help improve our society in the future. Now, in relation to Mr. Eddie Chu's motion, I don't think it is appropriate, and I think he is putting the cart before the horse. Let's take a look at the wording of the motion. He says that he is asking to summon the Secretary for Justice to attend before the Council on the 21st of March 2018 to testify or give evidence in relation to whether a law will be enacted, and if such law is to be enacted, what is the timetable? Well, Mr. Charles Mok said that we are already working on it. The LRC is doing consultation. It's just that it's being very slow. So should we be enacting as soon as possible Freedom of Information Act? We don't have to summon the SJ to answer that, because that issue is being dealt with by the LRC. You can say that we want you to do it faster. You don't have to summon the SJ. All you need to do is to write to the S4J. He said then the various government departments have been persistently withholding public information, and the SJ should testify or give evidence and to produce all relevant papers, books, records, or documents. So why was that needed? And that is something not related to the reform of the law and whether an archive law should be enacted. It seems that you don't want to do it, and it is said that government departments are persistently withholding public information. I don't think his query is well-founded or grounded. And I think the request is, the statement is rather vague. Government departments have been persistently withholding information. Under the present law, the government doesn't have the duty to disclose information. Mr. Kenneth Leung said that there are interdepartmental meetings, but they don't have the minutes. If they do have it, then they would have it. Then if they don't, then that means that they don't usually take minutes. And that means that they should improve on the operations. Even if there is an archive law, then that problem would not be tackled. Even if you have an archive law, you can't ask for information which doesn't exist at all. And the second part of the motion said that there has been persistent withholding of public information by government departments. What exactly is he referring to? It's not clear about that. The government does keep its own records. Of course, it does have a duty to keep certain information confidential. That is needed. Say, for example, for IRD, some 3 million people in Hong Kong are taxpayers, and over, say, 10 million organizations have to pay tax, and their information is with the IRD. Does it mean that whenever you ask for information, I should disclose that to you? It's not a question about withholding of public information. We should protect information of individuals and organizations. The government is not duty-bound to disclose all information to you. So there is no question of withholding of public information. If there are, say, litigation, say, civil or criminal litigations and so on, as long as the applicant can give reasonable grounds and seek for a discovery order from the court, the government will give you the information. So in the cases where there is no litigation and then you accuse the government of covering up or withholding information, that's not reasonable. And this accusation is, well, it seems that it is blaming the government. And I don't think the motion is really appropriate. Mr. Chow Smok referred to the fact that he's now drafting his private members bill, and the DOJ has been providing assistance to him. And what he is doing seems to go against the motion, because you're already working on it. Even if the government doesn't give you an answer whether they are going to enact the law, you will be nevertheless going ahead with your private bill. But whether it gets endorsed by the LegCo, then it would depend on the voting, which is done in a separate voting approach or manner. You know that what you're up to and what you're working on. Do you need to have this motion to ask the government whether you would do it and when, and ask the government to come to the LegCo on the 21st of March to tell us, no, I think that is a waste of time. Now, on the question of archive law, I support the notion that a society should get more civilized and get more open. We should not following strictly overseas practices. You mentioned about Sweden enacting the law in 1736 or 1766, but then the society has become more complicated these days. It should not be just the government who should be disclosing information. What about the NGOs, political parties? Members who voice out concerns of the public and who are trying to ask government on behalf of your electors, should we also be accountable to our electors? People would like to know why you are raising a certain question at a certain date. Maybe people will ask you why Mr. Eddie G will want to move a motion. The pro-establishment camp would think that you are trying to delay the proceedings. You are not sincere in moving this motion. And also, Mr. Eddie G, in your office and in the council, how did you discuss the matter with your assistants? We want a fair, open, transparent society. So the responsibility doesn't fall squarely on the government. The members should also be doing the same. According to the basic law, we should serve Hong Kong people. So what is our ideology? What are our motives, etc.? Maybe you had this motive in mind, but then later on you changed. And then say 20 years later, if you are to give an account to your, say, children and grandchildren of what happened, then would you be, say, disclosing information on what your mindset was, etc.? You have to give a clear account to the public as well. If you are to enact the archive law, it should not be just binding on the government. Well, we should study extending the scope. At least, I think, NGOs, political parties, and any lawmaker who promised to serve Hong Kong people, they should be covered. What they say, what they do, should be, say, part of the archive of Hong Kong, and they should be bound by this archive law as well. If we are really to do it, I think I will go beyond what you suggest. Let's do it with all the sincerity that we have. I think it's a progress, but would you agree to that? As to when the law will be enacted, what would be considered the right time? That we will look at the society's sentiment, how receptive they are to the archive law, and what is our own attitude. I think this is an interesting subject. The Law Reform Commission is studying into the matter now. Maybe in the terms of reference, we will see whether a wide enough scope is included. Maybe we can ask the SV.J to extend the scope in the terms of reference in relation to the archive law. I think this is a very interesting subject, but regrettably, we should not be moving this motion under Articles 73.5 and 73.10 of the Basic Law. I don't think you are doing it sincerely in a way. And President, I speak to object to this motion. Does any other member wish to speak? Mr. Horace Zhang. President, Mr. Eddie G, in accordance with Article 70(5) and 73, Article bracket 10 of the Basic Law, to move the motion. DAB and I myself will not support this. Mr. Eddie G asked to summon the Secretary for Justice to attend the Council. Now, in the wordings, his motive is to ask the SV.J to come before the Council to do two things. As mentioned by a member. First is whether a law will be enacted as soon as possible on freedom of information protected by the Hong Kong Bill of Rights Ordinance and when such a law is to be enacted. And the second purpose is to, in relation to the persistent withholding of public information by government departments at present, testify or give evidence and to produce all relevant papers, books, records, or documents. These are the main wordings of the motion moved by Mr. Eddie Chu. Regardless of whether the Hong Kong Bill of Rights Ordinance contains information as cited by Mr. Eddie Chu in his motion, that is, freedom of information protected by the ordinance. Now, in the ordinance, there is actually no direct mentioning of freedom of information. And I notice Mr. Eddie Chu just said, well, he was doing his very best to talk about Article 16 of the Bill of Rights Ordinance and try to link it up with freedom of information. Today, I'm not here to discuss whether Section 16 of the Hong Kong Bill of Rights of Ordinance, which is on freedom of expression, of opinion, does cover the freedom of information protected by the ordinance, as mentioned by Mr. Chu. I don't plan to query or have a discussion on this issue. Let's assume that there is indeed freedom of information protected by the Hong Kong Bill of Rights and Ordinance, and I will proceed with the discussion on that premise. Mr. Eddie Chu, in accordance with Article 73, bracket 5 of the Basic Law, summon the Secretary for Justice. And that 73(5) is about raising questions on the work of the government, and also bracket 10 is about summoning, as required when exercising the above powers and functions, persons concerned to testify or give evidence. Article 73 bracket 5 and Article 73 bracket 7, I wonder whether these have been invoked before. I've never looked into the records, but they are seldom invoked, I think. And Article 73 confers wide-ranging powers on the LegCo. We can raise questions on the work of the government or even summon anyone to attend before the council to give evidence or testify.
Mr. Eddie Chu is invoking Article 73 of the Basic Law, and he hopes to query the Secretary for Justice on whether she would legislate on freedom of information and when. President, is there a need to summons the Secretary for Justice through Article 73 of the Basic Law? Can we not obtain the necessary information through the LegCo mechanism? As for the Freedom of Information Act, you might realize that on the 4th of January this year, at the panel on constitutional affairs of LegCo, the Undersecretary was in attendance of the meeting. The government already submitted a paper. The title was the summary of the fourth report submitted by the Hong Kong SAR government in response to ICCPR. And this is a summary report, and the government hopes to consult LegCo. And in this summary report, in point 19, it mentions that the government would touch upon the issue of data requests. At the Constitutional Affairs Panel meeting, this issue was actually covered. So I wonder if members try to follow up on this issue at the CAP meeting. And under the LegCo system, apart from the CA panel, are there other means in which follow-up is possible? At Legislative Council meetings, we have oral questions, and we also have written questions. And on top of that, we have members' motions, and we have LegCo panels as well. And in the new Chief Executive question and answer session, members can offer questions or put questions to the government on all these occasions. However, Mr. Chu wants to summon the Secretary for Justice instead of putting his question to the Chief Executive. He's attending a question and answer session every week, but yesterday members chose not to raise this question. But members did not use this opportunity. Well, we will have the question and answer session every month. So why aren't we utilizing these means? The rights under Article 73 of the Basic Law are, of course, conferred to Legislative Council members, and we must be prudent and careful in using such rights. As Mr. Charles Mok said, he knew that work is underway on the Freedom of Information Act, and the Law Reform Commission is considering the issue. Even if the Secretary for Justice is summoned, she would say that work is underway and that she would consider the issues. If that's the case, what's the point of summoning her? Do we need to invoke BL 73 all the time if we have an option in front of us? Doesn't mean we are going to use it every single time. LegCo members fully know what their rights are. And just like the article to expel members of the press and public, of course we have such right, but are we going to resort to such powers every single time? I hope members would be prudent in exercising their rights. And as I said, the motion talked about persistent withholding of public information by government departments, and the Secretary is requested to produce all papers, records, etc. In the wording of the motion, I see no specific explanation on the actual papers or documents requested from the government. The motion simply says there is withholding of information by government departments, and so records are requested. When we apply for an injunction in court, Mr. Hoi-dick is requesting the Secretary for Justice to produce certain documents because someone is withholding public information. So in a court setting, when the judge decides whether or not to grant an injunction, the judge will see whether the wording of the motion is appropriate. In other words, if the judge grants the injunction or motion, the Secretary must produce all relevant papers, records, or documents. So, in other words, so what are the specific documents requested? If we pass this motion, Mr. Chu would ask the Secretary to follow this so-called order. So, what kind of documents must be produced by the SJ in order to comply with this order? What does she have to do? So this is of great significance, and members must consider this carefully. This is a fishing exercise in legal terms because you do not know what you are looking for. You are just trying to fish something or selfish something. If the wording of the motion is so loose, members must be very careful in considering the motion. The power to summon secretaries under the Basic Law is certainly a very solemn matter, and if you want fellow members to support your motion, your wording must be accurate, reasonable, and enforceable. But as I said, Mr. Chu mentioned persistent withholding of public information by government departments. What was he specifically referring to? We do not see the answer in the motion. So how can the Secretary produce the documents requested? President, the exercising of powers under the Basic Law is a solemn matter, and the wording of the motion must be very strict. Mr. Chu's invoke of the powers under the Basic Law is certainly loose, so myself and the DAB would stand against this motion. Does any other member wish to speak? Mr. Hon.CHU. Thank you, President. President, I speak against Ms. Eddie Chu's motion. I have followed what Dr. Junius Ho and Mr. Horace Chung said. If you have followed the LegCo meetings in recent weeks, Mr. Eddie Chu has moved a number of motions to summon government officials, and he prepared multiple motions of the same nature. As I have pointed out in recent council meetings, these motions apparently summon government officials, but the real objective is to paralyze the working of the government and LegCo. So it is a guerrilla move. Mr. Eddie Chu saw an opportunity, and he found this tool under Article 73 of the Basic Law. So I would call this a new form of filibustering by constantly summoning different government officials. If he succeeds, Lecco would have to deal with these motions, and a lot of subsequent motions would not be debated. So objectively, these motions are paralyzing the running of Lecco. Should we invest valuable time and resources on these motions at the expense of other more important motions or work? Is this what Lecco procedures are supposed to look like? I'm sure the public will have their doubts, and I hope Lecco would not spend so much time on issues or motions which are being dealt with. I'd like to talk about the wording of Ms. Eddie Chu's motion. He accused the government of persistently withholding public information, and because of such withholding of information, he asked when the SAR government would legislate on this issue. So I'd like to offer some context. If I'm to discuss this issue with Ms. Eddie Chu, we have to identify the current problems in the maintenance of information and whether the government's handling of information requests are being questioned. If you ask the government to explain their work or certain issues, Lecco has established means and procedures to request information or documents from the government. For serious incidents, Lecco is empowered to request certain documents from the government. So Lecco is empowered to do these things. If the government is required to produce past records, and if such records can help answer certain questions, well, in recent times, we have been discussing the archives law.
President, allow me to say this about the archive law. If you have been paying attention to the work of the Lecco under the CA panel, we have held a meeting, and it was on the 15th of January. There was an agenda item on the making of the archive law. I need to go into the background. This term of government has promised through the CE that it will trigger a study on the future making of an archive law. We are also aware that the LRC has already started a comprehensive study into the making of an archive law. And as before, the LRC does very careful studies so that if legislation has to be made in future, the product of the LRC's research will be very helpful. So we can see that to a certain extent, we should say that the work is already underway. As I was saying, we are waiting for the research of the LRC to be completed. I also hope that the LRC can complete its study ASAP, so we can discuss the results and comment on them, so that when we take the next step to make the archive law, we will stand to benefit. President, we can see that this is already being done. Mr. Chu is saying that there is persistent withholding of information by government, and maybe the administration has given people the impression that regarding the archive law and regarding its poor handling of valuable archives, and if you want it to do better, then I can tell Mr. Chu that actually work is already underway. I can't therefore see why suddenly we want to summon the S for J to give so-called accounts or explanation. Even if she comes, probably she will just be able to tell you that the LRC is doing relevant research. Maybe she has her viewpoints regarding an archive law. Say, for example, that other places in the world have archive laws and the UK did so many years ago. Maybe she can share with us some of her own viewpoints. But I can't see why we suddenly want to summon her here except to have her share her viewpoints with us. Can it really help with promoting this matter? On the contrary, since Mr. Eddie Chu is moving the motion, so we have the time to express our views on the issue, then allow me to say that Hong Kong, of course, lags behind other places in making an archive law. The SARG has already got an established mechanism to keep records. According to my research and understanding, the administration does categorize its records. The archive department separates the records into administrative records and business records. Mr. Hou-dick, we are not talking about an archive law. Please come back to the motion. Sorry, President. This is a little related, but I wouldn't spend too much time on it. Suffice it to say that we already have a mechanism to deal with records. Of course, it's not a law. There were voices in society that the administration had not done a good job with its archives, and that is why we said there should be a review and that there should be some legal regulation. I'd just like to let you know the background. Coming back to this motion, Mr. Eddie Chu is saying that if there is persistent withholding of information and he wants the administration to supply information, documents, or replies. I heard Mr. Horace Chung. Well, we are both practicing lawyers, and I subscribe to his legal viewpoint, and I would repeat it here. When you ask people for information, I think that the court is very fair. It doesn't want to see you exploiting the system, and that is to request information from the other party in order to achieve other purposes. Say, for example, you request for a lot of information. Basically, you know you may not be able to get it. However, you still want to make the request and you are abusing the system and wasting time. At the court, if it is a litigation, if either party requests the other party to supply information and if it does a fishing expedition, the court will not allow it. And in the end, he may be awarded costs. As Mr. Chung was saying, this is a fishing expedition, and the court doesn't want to see this. President, the court is always fair. It will make a judgment as to whether you are engaging in fishing expeditions, whether you are abusing the mechanism or system. Because in fact, you don't really want to get what you are requesting, but even if there is a slim chance of getting something, you just ask for it anyway. Looking at the wording of the motion from Mr. Chu, he is of the view that there is persistent withholding of information, but I haven't seen or heard him say, quoting or any examples or incident, but he is summoning the SPJ to testify. But what he said is rather broad. He is asking the SPJ to come to see whether it is possible to legislate on freedom of information as protected by the Hong Kong Bill of Rights Ordinance. Well, even on this one, frankly, Mr. President, this is a very wide scope. I wouldn't impute motives to members, of course, but the objective effect is when you do this, after the public have listened to you, then undoubtedly they may think that you are doing a fishing expedition, as the court will call it. Because of the reasons I stated, I object to the motion moved by Mr. Eddie Chu today. And I will reiterate that the work of the Council is already quite enough for us to handle. And if the mechanism of the Council is abused, and if members can embark on fishing-like expeditions, I think you are wasting the time and resources of the Council, and it's not a good thing for the public. I hope the Council can go back to its right track, so the Council and society can go back to the right track. Does any other member wish to speak? If not, SCMA?
主席
President. 6 members spoke on the motion. As I said at the beginning of this debate, the administration has always abided by the principle of openness and transparency in providing information to the public. We understand that the public have high expectations of the government becoming more open and transparent. In fact, members of the public have also made more requests to departments for information. In 2016, 2017, a total of 5,500 requests have been received according to the code. This is the highest so far. In the second quarter of last year, we also received almost 1,500 cases or requests for information. Bureaus and departments have always tried their best to tackle every request for information under the code. The code was launched in March 1995, and 96% of the cases had all the information supplied. It's a very high proportion, and it goes to show that the administration follows the code to the letter. It is only in 2% of the cases that, because of the reasons in Part 2 of the code, that they have been rejected. And in another 2% of cases, only part of the information requested has been supplied. These are very high figures, and we can see that we compare rather favorably with other jurisdictions. According to the UK figures, in 2016, only 46% of the cases got all the information requested supplied. We are 100% more than UK. And in 14% of the cases in the UK, only part of the information was supplied. And for Australia in 2015-16, 56 of the cases got all the information that they requested. And again, we are way above them. And 34% got part of the information supplied. We can therefore see that what the motion said about the government departments withholding information was unfounded. This is an unfair accusation. It doesn't hold water. As a matter of fact, the code protects the right of the public to get information. According to the code, if members of the public are of the view that bureaus, departments do not follow the code, they can request the bureaus, departments to review the cases. Apart from this review mechanism, the code also provides complaint channels. If the applicants are not happy, they can go to the Ombudsman to lodge a complaint. The Ombudsman will conduct independent studies or investigation. As for the formulation of a freedom of information law, as I said at the beginning, the code or the Access to Information Subcommittee of the LRC, as some members mentioned, is now conducting a detailed review and study into the issue. The subcommittee has gone into the stage of drafting a consultation paper. According to present progress, the subcommittee estimates that it can release a consultation paper this year to consult the public. The subcommittee will consider views collected during the consultation in order to decide on reform proposals. The LLC will consider the views of the subcommittee and it will issue a final report. The administration will continue to pay close attention to reports released by the LRC, and we will consider the reports carefully in order to consider how to reform the present access to information system, and we will include the consideration of the making of a freedom of information law. You can therefore see that the motion moved by Mr. Eddie Chu is inappropriate and unnecessary. President, I so speak to object to the motion moved by Mr. Eddie Chu.
I now call upon the Hon.CHU Hoi-dick to reply. Then the debate will come to a close. The Hon.CHU Hoi-dick. Thank you, President. I would like to thank so many members and the Undersecretary's response. I will not be responding to each and every point you made. For those who think that I am not right in moving this motion, please take a look again at what I said, or the speeches made by fellow members. There are many cases, say from the purchase of water cannon vehicles by the police to the Hong Kong Palace Museum, the Wangchao incident, and the Hong.CHU Macau Bridge, the traffic flow, and the loan situation. I've cited these cases myself, and I pointed out that the government, in relation to major issues, have not been able to give a clear account to the public and legislators. If we want to advance or to develop democracy in Hong Kong, we need open data or information. It's not just about news reports at different TV stations or filling up the spaces in newspapers that's acceptable. No. What we are asking is that the government should be bound by a law so that a member of the public or a legislator can have the right to access to government information. Well, the information, after all, doesn't belong to the government exclusively. It belongs to all. Only by doing so can we develop further democracy in Hong Kong, or else we'll be kept under wraps, kept in the dark all the time. So there is no way that we can promote democracy in Hong Kong. Now, President, I would particularly like to respond to the Under-Secretary's mentioning about the figures on access to information requests. And also, he said that some 90% of the requests were entertained. And the Under-Secretary said that this means that the government is not withholding information. If you say this to members of the public, then everyone would think that you are playing around with the figures and try to keep under wraps the facts which are known to everyone. Well, we talk about Disneyland, Link, and the co-location issues. Information related to all these issues is not released to the public at all. How come that you have got a high sort of success rate here? I'm not speculating. Actually, a lot of my friends I've got a lot of journalists friends, members of the civic bodies are my friends, and they think it's hopeless to try to get information from the government through the Code of Access to Information. It's just because of this that the figure is so low. Every year you have less than 10,000 requests. But Mr. Chow Smok raised an oral question last year. He was asking you not only about the Code of Access to Information, just tell us the number of requests made not based on the Code of Access to Information. You said that the government compiles statistics on such requests. Maybe there will be in hundreds of thousands or even millions of requests for information. How much information have you released to the public? You just talk about Code of Access to Information, and people really don't trust you if we look at what's happened in reality. So that's why we hope that the Secretary for Justice can attend before the Council and have a dialogue with us. And I must emphasize, President, that we are not asking her to be here only. Well, some colleagues would say that she would just regurgitate what's been in the response to the oral question. Now, the wording of the motion is that whether she will enact a law on freedom of information and when it will be enacted. And she should also testify or give evidence and to produce all relevant papers, books, records, or documents. That has never been done by any government official in the past. On the freedom of information legislation, the government has been talking about it all along only. And as members have pointed out, they would just say that they have hand over the task to the LRC, they will wait for the report, and then there will be a consultation document. We don't want remarks or responses like those. We want the government to tell us whether it will enact or legislate on freedom of information and whether there has been any discussion held, documents prepared, records kept, etc. And she must give an account of that kind of decision, and that's never been done in the past. At this very critical juncture in Hong Kong, Hong Kong has been sort of overpowered by Beijing and oppressed on all fronts by Beijing. And if we talk about Freedom of Information Act at this juncture, our people will tell me, be realistic. They won't reason things out with you anymore. Please, members of the public, understand that the democratic camp will work together with the public to build a democratic system in Hong Kong. We just don't talk. We should not be just talking about double universal suffrage. At all spheres of life in Hong Kong, we should work together with Hong Kong people to build a very solid foundation for democracy in Hong Kong. And Archive Law, Freedom of Information Act, sharing information are things that we should not forget when we talk about building the basis. Even if this is a difficult time, members of the public should have that kind of awareness. Dr. Junius Ho said that there is no law allowed, so you can't accuse the government of covering up or withholding information because we don't have a law based on which we can accuse the government. We should not think like Dr. Junius Ho. We are really the masters of the city, masters of the information, masters of government records. They are not the private properties of the government. The information belongs to us. So that's why we ask for legislation on the part of the government to clearly spell out that these are rights. Please, members, I appeal to your support of the motion. I now put the question to you that the motion moved by Hon.CHU Hoi-dick be passed. With those in favor, please raise their hands. Those Ms. Tenny Chan claims the division. The division bout will be around for 5 minutes.
開始表決。
Voting begins. Please check your votes. Voting is closed. The results are displayed. From the FCs, 22 present, 3 for, 18 against. From the GCs, 18 present, 7 for, 11 against. The question is not agreed by majority of each of the two groups of members present. I declare the motion negatived. Council is now adjourned till the 7th of February at 11:30 to facilitate the CE's question and answer session. The council meeting will begin immediately after the end of the session.